Ralph, can you give us an overview of what your experience has been like with challenging USCIS denials before this decision came out?
Yeah, so before this decision, for I-485, specifically for denials for adjustment of status, the district court remains a useful venue. Well, of course, the biggest concern in those cases is that the government can always get out of the district court jurisdiction by putting the person in a removal proceeding. But that doesn't happen all the time, either for situations where the plaintiff is actually in lawful status, where they may not have a ground of removal, or the government may decide that the USCIS decision is actually wrong, so they are willing to reopen and approve the case. Of course, sometimes they may issue another RFE to kind of fight you a little bit, but overall, I think there's also a circuit split here in some circuit where the district courts may say this is discretionary, we just don't have jurisdiction, but in certain circuits, the district court will take up jurisdiction, especially for questions related to a constitutional issue or question of law.
Yeah, I know the Second Circuit, the 11th Circuit, and the 8th Circuit will have limited review or permit limited review of discretionary denials if there's a precatory decision or a non-discretionary decision that leads to the denial of the discretionary benefit. So if you have a situation where they say you committed fraud and there's case law on how fraud is determined, if that's the reason why the case is denied, in those circuits, they would let you challenge that possibly. Whereas if they say, if USCIS eloquently writes, in our discretion, we're denying the 485, at that point, you might even lose in those circuits. So it's definitely, you have to do your research.